Okay, will versus trust. How do they work? Which one is better? When do they take effect? What should I know? If you've been looking for answers to these questions, then this is the video for you. Stay tuned. Hey guys, Elliott Feldman here, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. If you ever have any questions about this topic or need to talk about your estate planning needs, you can schedule a time to talk with me over the phone for free by going to myestatemeeting.com. Okay, wills and trusts are two of the most commonly used estate planning documents, and they form the foundation of most estate plans. Now, while both documents are legal vehicles designed to help you distribute your assets to your loved ones upon your death, there are many differences that you should be aware of. The first difference between a will and a trust is that a will does not avoid probate court for your family. You see, when you die solely owning an asset in your personal name, like a house, probate court is the legal process that your loved ones have to go through in order to transfer the ownership of the asset out of your deceased name and transfer the ownership of those assets into your loved ones' names who are currently living, based on who state law says ultimately to give your assets to, or based on who you declare that you want to give your assets to in your will. But notice, even if you have a will, your loved ones still have to go through this legal probate court process in order to get ownership of your assets. And this probate court process can last up to 9 or to 18 months or even longer and cost your family up to tens of thousands of dollars by the end of it. I would know. You see, when my dad died, my mom, she had to go through almost 3 years of probate court and had to pay her probate attorney $55,000 by the end of it. Now compare that to a revocable living trust, which are becoming much more popular among many middle-class families these days because unlike with a will, you transfer the ownership of all of your assets to your trust during your lifetime and state who you'd want to inherit those assets after you die. So when you pass away, you own nothing in your personal name, which means your family does not need to go through 9 to 18 months of probate court and pay up to tens of thousands of dollars just to get ownership of your assets. In fact, they can get ownership of your assets in a matter of weeks in the comfort and privacy of an attorney's office. No court, no conflict, no delay with a trust. The second difference between a will and a trust is the time they take effect. You sign your will, but your will only goes into effect after you die versus you sign your revocable living trust and your trust goes into effect immediately. Because a will only goes into effect after you die, it offers no protection in the event that you're alive but become incapacitated and are no longer able to make decisions about your financial, legal, or healthcare matters. If you're incapacitated and only have a will in place, then your family cannot enter your financial accounts to pay for expenses on your behalf. In fact, your family will actually have to petition the court to appoint a conservator or guardian to ultimately handle your financial affairs, which can be costly, time-consuming, and very stressful on your loved ones. And there's always the possibility that the court could appoint a family member as a guardian that you never want to make such critical financial decisions on your behalf, or the court might even put in place a total stranger to be in control of just about every aspect of your life and leaving you open to potential fraud and abuse by crooked guardians. Kind of like what happened in the Netflix movie I Care a Lot. Now compare that with a trust, which takes effect immediately and allows you to include provisions that appoint a family member of your choosing to be your trustee with the legal power to access your assets and make sure the bills are getting paid while you're alive and incapacitated. When combined with a well-drafted medical power of attorney and living will, a trust can keep your family out of court and conflict in the event of your incapacity while ensuring your wishes regarding your medical treatment and end-of-life care are carried out exactly the way you want. The third difference between a will and a trust really concerns the assets that they cover. A will covers any assets solely owned in your personal name when you die, but it does not cover property co-owned by you with others, nor does your will cover assets that pass directly to your loved ones via beneficiary designations such as life insurance and retirement accounts. Now, trusts, on the other hand, cover any asset that has been transferred into the name of the trust, so the trust itself owns the asset. It will even cover assets or policies that have ultimately made the trust as a designated beneficiary upon death, such as your life insurance and retirement accounts. That said, if the ownership of an asset hasn't properly transferred to the trust, it won't be covered by the trust provision. So even if you have a trust, if you didn't transfer the ownership of your assets into it during your lifetime, then your family will still need to go to probate court. So in summary, if your estate plan consists of a last will and testament alone, you are guaranteeing your family will have to go through a mess in probate court if you become incapacitated or when you die. Only a trust fully funded with assets will keep your family out of court and out of conflict. Wills ultimately only become effective at death. Trusts become effective immediately. A will only covers certain assets after you die. A trust can cover virtually all of your assets as long as you transfer the ownership of those assets to the trust before you died. So what's the right option for your family? Honestly, prescribing medicine without consultation is malpractice. Look, the best way for you to determine whether or not your estate plan should include a will, a revocable living trust, or some combination of the two is first, ultimately you got to have that initial conversation with an estate planning attorney. And if you'd like, you're more than welcome to schedule an initial 15-minute call with me at a time that works for you and your spouse if you're married by going to myestatemeeting.com. Hey, thanks for taking the time to watch this video. Don't forget to hit that subscribe button and the notifications bell next to it to be notified for new videos I post each week. And if you like it, then please hit the like button. And if you know someone that needs to hear this, please share it with them. If you have a question or comment, please leave one. And if you ever have any questions about this topic or need to talk about your estate planning needs, you can set up a time to talk with me over the phone for free by going to myestatemeeting.com. That's myestatemeeting.com. Again, this is Elliott Feldman, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. Take care.